So if you wanted to, like, prosecute a government for genocide today, you would pull out the 1948 United Nations Convention. You'd look at the specific legal criteria, you'd gather all your evidence, and you'd present your case.
Right. It's a very standardized process now.
Exactly. But what happens when you take that exact piece of paper, you essentially travel back in time, and you apply it to 250 years of United States history? Today, in this deep dive, we are basically putting the American frontier on trial.
Yeah, we are. And it is the ultimate exercise in diagnostic muddy waters.
It really is. We're looking at the historical record of U.S. Indian policy through a lens that was manufactured, decades after these events actually happened. And the verdict might completely upend how you view the American story because, as we found out in the sources, the crimes that seem the most obvious to us morally, well, they actually turn out to be the hardest to prove legally.
They do. We are undertaking an unprecedented legal and historical reckoning today. And it's really vital to acknowledge the immediate paradox here for you, the listener. I mean, the men who designed and executed these 19th century policies were never charged.
Right.
They weren't charged because the specific atrocity crimes they might have been accused of, well, they literally did not exist in the law at the time they were acting.
Which is wild to think about.
It is. But our organizing question for this deep dive is very precise. If the modern law of atrocity crimes had existed in the 19th century, which American administrations and which specific acts would face charges?
Right. And before we get into the actual evidence, we need to be incredibly clear about what this deep dive is and, what it isn't. Because this isn't a political polemic.
No, not at all.
We're not doing this to score points in some modern culture war or to take a left-wing or right-wing stance. We are just impartially reporting on what the source material presents.
Exactly. And because of the nature of the source material, which, we should warn you, deals extensively with the documented deaths of children, mass violence, and systemic erasure, our tone today has to be measured.
Yeah.
It's documentary. It is grave. We are going to calmly lay out the prosecution's case based strictly on international law, and then, crucially, we are going to vigorously and fairly steelman the defense's counterarguments.
Because we aren't handing down a final verdict here.
Right. We're just laying out the evidence so you can weigh it yourself.
So, to put history on trial, I guess we first have to build the courtroom, right? We have to clearly define the specific legal instruments we're actually using. Because we throw around phrases like crimes against humanity all the time in the news today.
Oh, constantly.
Yeah, we treat them like they're these ancient universal laws handed down on stone tablets. But legally speaking, that phrase is basically brand new.
It really is. I mean, it's younger than the airplane. The concept of crimes against humanity as a prosecutable international legal offense was first codified in August 1945.
Right after World War II.
Exactly. It was written into the Article 6C of the Nuremberg Charter by the Allies, specifically to prosecute the leadership of Nazi Germany.
And when you look at the text of Article 6C in the sources, the core legal element is actually quite specific. It defines acts like murder, extermination, enslavement, or deportation. But the threshold that elevates those acts to a crime against humanity is that they must be committed as part of a, and this is a, quote, widespread or systematic attack directed against any civilian population.
That's the key bar right there.
Right. It can't just be an isolated skirmish.
No, it requires scale. It requires systemization against civilians. But then, we move to a term that carries even heavier historical weight and an even stricter legal burden, which is genocide.
Yeah, that word is heavy.
The origins of this word are just deeply tragic. It was actually coined in 1944 by a Polish Jewish jurist named Raphael Lemkin.
Lemkin's story in the source material is incredible. I mean, he fled the Nazi invasion of Poland, but he lost almost his entire family in the Holocaust. And he found himself in this position where the English language simply didn't possess a word capable of describing the specific mechanical horror he was witnessing.
Yeah, he needed a word for the deliberate destruction of a nation or an ethnic group. So he basically built one. In his 1944 book, which is called Axis Rule in Occupied Europe, he took the ancient Greek word genos, meaning race or tribe, and he combined it with the Latin suffix side, meaning killing.
Genocide.
Exactly, genocide. And he didn't just invent the word in a book and walk away. I mean, he campaigned tirelessly.
Like he was practically harassing diplomats in the hallways of the United Nations.
Yeah, absolutely. He was relentless in getting it recognized as an international crime.
And he succeeded, because in December 1948, the UN adopted the Genocide Convention. And the precise legal definition in Article 2 of that convention is what we are going to be using as our main tool today. It defines genocide as acts committed with the, quote, intent to destroy, in whole or in part, a national, ethnical, racial, or religious group as such.
I really want to pause on that phrase, intent to destroy the group as such. That right there is the fulcrum upon which this entire historical trial balances.
Because proving intent is incredibly difficult. I was really trying to wrap my head around this while reading our sources, and it feels like an architectural distinction to me.
How do you mean?
Well, it's like the difference between a terrible landlord who completely neglects a building until the load-bearing pillars crumble and people tragically die, versus a guy who goes out, buys dynamite, and meticulously plants it at the pillars with the specific goal of bringing the building down.
Ah.
Yeah. Mass death alone, I mean, even if it's the result of catastrophic negligence or a terrible policy, isn't legally genocide. You have to prove the government actually bought the dynamite.
That is a highly accurate analogy. The physical act of destruction has to be inextricably married to the mental element, the specific documented goal of erasure. Rome Statute, which eventually established the International Criminal Court.
Right.
The modern definitions of crimes against humanity and genocide remain virtually identical to those post-World War II texts.
But the United States' relationship with these laws is deeply conflicted, isn't it? I mean, the U.S. helped write these laws after World War II. They signed the Genocide Convention in 1948, and then they just sat on it for 4 decades.
Yeah, they didn't ratify it until 1988 under the Proxmire Act, and even then it was passed with very specific reservations.
Why the 40-year delay, though?
A significant part of that hesitation, and this was heavily debated in the Senate at the time, stemmed from a profound fear that this very treaty might be turned backward against the U.S.
Oh, wow.
Yeah, lawmakers explicitly worried that international courts could use the UN definition to prosecute the United States for the exact 19th century policies we are examining today, as well as for the domestic history of segregation and Jim Crow.
So they basically knew the skeletons in the closet might fit the definition.
Exactly. And it's worth noting, the United States has still never ratified the 1998 Rome Statute.
Okay, so we have our tools now. We know the difference between the widespread attack on civilians required for crimes against humanity and the intent to destroy required for genocide. So let's start applying these tests to the 19th century record.
Right. Let's look at the evidence.
And logically, I think we have to start with the policies of mass forced relocation in the 1830s.
The era of Indian removal. So here we are looking primarily at the policies of Presidents Andrew Jackson and Martin Van Buren, roughly between 1830 and 1838. The most infamous resulting event is, of course, the Cherokee Trail of Tears, though it affected many southeastern nations.
So when I look at the logistics of removal, the military rounding people up into stockades, the forced marches over thousands of miles, the massive death tolls from exposure and starvation along the route that feels like a one-to-one match for crimes against humanity.
Oh, absolutely.
Because it perfectly fits the text, right?
Yeah.
Deportation or forcible transfer of population as a systematic attack on civilians.
It fits the standard of a crime against humanity almost flawlessly. The population was targeted, the transfer was forced by the state apparatus, and it was undeniably systematic. However, when prosecutors attempt to upgrade this charge to genocide, the legal framework starts to really struggle.
Because of the intent requirement.
Yeah.
The dynamite analogy again.
Exactly. Returning to your dynamite analogy, the architects of removal, like Jackson, argued, however self-servingly or paternalistically it sounds to us today, that the stated aim of the policy was relocation to prevent extinction.
Wait, they argued it was to prevent extinction?
Yes. They framed it as separation for survival. They argue that if native nations remained in the East, they would be inevitably annihilated by encroaching white settlers. So the government had to move them west.
So even if the outcome was catastrophic death and suffering, the stated intent in the congressional record wasn't destruction, it was geographical removal.
Precisely. You would have a very, very hard time proving beyond a reasonable doubt in an international court that Jackson's specific intent was the physical destruction of the group as such.
Okay, so if removal was framed as separation to avoid the genocide label, that legal shield completely disintegrates when we look at instances where the military wasn't escorting people but actively hunting them. Which brings us to the massacres.
Yes.
Let's look at Sand Creek in 1864 and Wounded Knee in 1890.
These events shift the legal analysis significantly, because here you aren't dealing with the complicated logistics of a forced march. You are dealing with direct, kinetic military violence against non-combatants.
The details of Sand Creek in the sources are staggering. In November 1864, Colorado Volunteer Cavalry, led by Colonel John Chivington, attacked a camp of Cheyenne and Arapaho people. And our sources emphasize that this camp fully believed they were under military protection.
They did.
They're actually flying a United States flag and a white flag of truce above the chief's lodge. And the troops just attacked anyway, killing up to 230 people, the vast majority being women, children, and the elderly. And then they mutilated the bodies.
It was horrific. And then at Wounded Knee in December 1890, the 7th Cavalry intercepted a band of Minneconjou Lakota. During a very chaotic disarmament process, a shot was fired, and the cavalry basically opened up with Hotchkiss mountain guns.
Those were basically early artillery, right?
Firing explosive shells. They killed between 250 and 300 Lakota, again including massive numbers of women and children who were just fleeing into the ravines.
So, under the Rome Statute, both of these are undeniable crimes against humanity, right? They are systematic attacks directed against a civilian population. But do they cross the threshold into genocide? I mean, if the military is doing it, isn't that federal intent by default?
You'd think so intuitively, right? But legally, the road actions of a specific commander in the field don't automatically prove the genocidal intent of the entire federal state apparatus. For Wounded Knee, scholars fiercely debate whether it was a tragic, botched military operation that devolved into a massacre out of chaos, or if it was a premeditated act of extermination.
Right. Proving the premeditation is a hard part.
Exactly. But Sand Creek presents a much more chilling convergence for a prosecutor.
Because we actually have Chivington's intent on the record.
Yes, we do. Chivington's own rhetoric supplies the specific mental element required by the 1948 convention. He famously declared, "Kill and scalp all, big and little, nits make lice."
Wow, nits make lice.
Yeah, that is a documented, direct expression of intent to destroy a group down to its children. Interestingly, though, the federal government's reaction at the time complicates the narrative of a monolithic federal genocide.
How so? What did the government do?
Well, a Congressional Joint Committee actually investigated Sand Creek. They condemned Chivington in the most scathing terms possible. They officially called it a foul and dastardly massacre.
Really? I didn't know Congress actually investigated it at the time.
They did. Yet, because he had already resigned from the military by the time they concluded, he was never criminally punished. So you have a situation where a rogue commander expresses genocidal intent, commits the act, is condemned by the state, but escapes justice.
This friction between executive action, military violence, and the pursuit of justice leads us perfectly to the Dakota 38. This is a highly specific event from 1862 that tests these legal boundaries in a really, really uncomfortable way.
It does. We are talking about the hanging of 38 Dakota men in Mankato, Minnesota on December 26, 1862, under President Abraham Lincoln. It remains, to this day, the largest mass execution in United States history.
And this happened in the aftermath of the U.S.-Dakota War. But to understand the legal violation here, we really have to look at the mechanics of the trials that led to the hangings. Because based on the sources, they weren't trials in any modern sense of the word.
Yeah, not at all.
The military essentially set up an industrial processing plant for death sentences.
They were military commissions. And you're right, the speed and lack of due process were horrifying. Nearly 400 Dakota men were tried in a matter of weeks. Some of these trials lasted only 5 minutes.
5 minutes.
Yes. The defendants had no legal counsel whatsoever. The standard of evidence was incredibly low. Often they would simply ask if the man had been present at a battle, and if he said yes, they issued a death sentence. They ultimately condemned 303 men to death.
But then President Lincoln gets involved, right? He demands the trial transcripts be sent to the White House. He and his lawyers personally review the cases, and Lincoln decides to commute the sentences of over 260 men, reducing the condemned list down from 303 to 38.
Right.
He specifically tried to separate those who only participated in battles from those accused of massacring civilians.
Which creates a massive analytical challenge if you are a prosecutor trying to prove genocide.
Right. And, I mean, I hear the legal argument here, but as a human being, it just feels incredibly clinical. It feels like a massive loophole to say, well, Lincoln spared 260 people, so executing 38 without due process isn't genocide.
It does feel clinical, I completely agree. But that is the nature of strict legal analysis. If a prosecutor's burden is to prove the specific intent to completely destroy an ethnic group, the documented act of a head of state intervening to actively spare over 200 lives actively fractures that argument.
Because it shows the opposite of intent to destroy everyone.
Exactly. It demonstrates restraint, not a desire for total annihilation.
So legally, if it isn't genocide, what is it?
The Dakota executions are much more accurately classified as a horrific mass denial of due process, a reprisal execution, and arguably a clear war crime. It is a profound injustice, without a doubt, but it does not meet the specific, narrow UN criteria for genocide.
Okay, so up until this point, we've seen how difficult it is to pin down federal intent. Removal was framed as relocation. Sand Creek was blamed on a rogue commander. Lincoln showed executive restraint. You can constantly find a legal gray area if you look hard enough.
You can.
But our sources point to one specific geographic and temporal location where that gray area completely vanishes, where the intent and the action lock together flawlessly. And that is California.
The California catastrophe, spanning from roughly 1846 to 1873, represents a seismic shift in our legal analysis today. This is the period immediately following the U.S. conquest of California from Mexico, exploding right into the gold rush.
The demographic collapse here is just hard to fathom. Historian Benjamin Madley, whose work features really heavily in our sources, estimates that in a quarter of a century, the native population in California plummeted from roughly 150,000 down to about 30,000.
It's a staggering drop. And while disease and starvation played significant roles, Madley's research meticulously documents that up to 16,000 of those people were killed outright, directly murdered.
But what makes California different from the other massacres we talked about? Why does the legal gray area vanish here?
Because of the bureaucratic machinery that drove the violence, these were not just spontaneous acts by greedy gold miners who were acting outside the law. This was a systematic, state-funded campaign.
Right.
The brand new state of California legally authorized the formation of volunteer militias specifically to hunt native Californians.
And they were keeping receipts, weren't they?
Literally keeping receipts. These militia commanders would buy ammunition, supplies, horses, and then they would submit itemized invoices to the California state legislature. The state authorized over $1 million in bonds to pay these militias.
Over $1 million back then.
Yes. And crucially, because state budgets were tight, California then petitioned the federal government for reimbursement. And the U.S. Congress actually passed laws to reimburse California for the expenses of these killing campaigns.
So the physical act of mass killing is undeniably present. The state and federal funding machinery is documented. But what about the intent? We need the dynamite, right? We need the explicit goal of erasure.
And here, the smoking gun of intent isn't hidden in some secret diary. It is right in the official state record. In 1851, the very first governor of California, Peter Burnett, delivered an address to the state legislature.
And this is what he said. I have the quote here, that a war of extermination will continue to be waged between the races until the Indian race becomes extinct, must be expected.
A war of extermination until the Indian race becomes extinct. When you apply the 1948 legal standard, this is the rare historical moment where you have a perfect storm.
Yep.
You have the physical act of mass killing. You have the bureaucratic funding mechanism paying for it. And you have the explicitly documented destructive intent declared by the highest executive authority in the state.
They basically said the quiet part out loud.
They did. And this is why leading historians argue that California is the clearest, most indisputable case of genocide in American history. It meets every single burden of proof required by the UN Convention.
So California gives us the clearest evidence of physical destruction. But as we move later into the 19th century, the sources guide us to a totally different clause in the UN Convention. What if the international law didn't just generally apply to the era, but actually described a specific U.S. policy word for word?
This is where we have to look closely at Article 2, Clause E of the 1948 Genocide Convention. Most people just assume genocide strictly means mass murder.
Right, that's what comes to mind.
But Clause E explicitly defines genocide as, quote, forcibly transferring children of the group to another group, provided it is done with the intent to destroy the group.
Forcibly transferring children of the group to another group. That brings us directly to the off-reservation federal Indian boarding school system.
It does. The foundational architecture for this system was laid in 1879 by an Army officer named Richard Henry Pratt. He founded the Carlisle Indian Industrial School in Pennsylvania. And Pratt, well, he wasn't hiding his goals either.
Yeah.
He established the guiding philosophy for the next half-century of federal policy with a chilling, now infamous slogan, "Kill the Indian in him and save the man."
Kill the Indian.
the heck
That
of
is a
that?
direct, unfiltered statement of intent to destroy a cultural and social group, even if the physical body of the child is kept alive. And the mechanics of how they achieve this are just devastating to read about.
Yeah.
Pratt built a totalizing environment designed to sever every single connection a child had to their past.
The everyday logistics were essentially militarized assimilation. When children arrived at Carlisle, or any of the hundreds of schools modeled after it, they were immediately stripped of their traditional clothing. Their hair was shorn, which, in many native cultures is a practice strictly reserved for mourning.
Right.
They were forbidden from speaking their native languages, often under threat of severe physical punishment, and they were assigned English names.
They were systematically dismantling their identity piece by piece. But what really anchors this legally for our mock trial is the sheer bureaucratic scale of the operation. We aren't just relying on historical anecdotes here. We have the federal government's own modern accounting.
This is a crucial development in the historical record. We are relying heavily on the recent findings of the Federal Indian Boarding School Initiative. This was launched by Interior Secretary Deb Haaland, who is the first Native American cabinet secretary.
And she oversaw the release of two massive, unprecedented investigative volumes in 2022 and 2024, right?
Yes, she did.
And the numbers they uncovered are just staggering. They documented the existence of 417 federal Indian boarding schools across 37 states or then territories, and the funding required to move that many children is immense. Between 1871 and 1969, the federal government appropriated over $23.3 billion, and that's adjusted for inflation to $2023 to fund this school system and related assimilation policies.
$23 billion dedicated to the forcible transfer and assimilation of children.
And then there's the mortality data, which is the hardest part to read.
The Highland reports documented at least 74 marked and unmarked burial sites at 65 of these school locations, and they established a documented floor, meaning a minimum baseline, based only on the surviving records they could find of at least 973 child deaths within these schools.
973 children. And they explicitly state they fully expect that number to rise into the thousands as more records are unearthed and analyzed.
So when we bring this back to our courtroom, this creates a unique legal convergence. The boarding school system is arguably the strongest single legal fit in the entire American record for the crime of genocide. It perfectly matches the specific mechanism outlined in Article 2E.
And the prosecution's star witness is the U.S. government itself. I mean, the key exhibit is the government's own internal audit.
Exactly. The evidence isn't extrapolated from angry letters. It has been officially investigated, documented, and published by the state that committed the acts.
Okay, we've heard the prosecution, we've laid out the law, we've looked at the massacres, the state-sponsored violence in California, and the billion-dollar machinery of the boarding schools. But a reckoning that only acts as a prosecutor isn't a true reckoning.
No, that's just a show trial.
Right. To be intellectually honest, we have to invite the defense into this courtroom. We have to give their counter-arguments a full, rigorous hearing.
And the defense has several highly substantive arguments that challenge the entire premise of our exercise today. We must start with the most foundational legal principle at play here. Nullum crimen sine lige.
No crime without a law.
Precisely. It is a bedrock principle of modern justice. It is enshrined in the very international human rights instruments we are discussing today. The defense argues that you cannot justly convict someone or hold them legally liable under a law that simply did not exist at the time they committed the act.
I hear that, but again, my modern brain really struggles with it. Isn't that just a wildly convenient legal technicality? I mean, just because there wasn't a UN statute on the books against mass murder in 1851 doesn't mean it wasn't mass murder. Murder is murder.
It's a very natural reaction to have, but we have to distinguish between different types of judgment. International criminal law is designed to indict and try specific living individuals. A prosecutor must prove an individual's guilt beyond a reasonable doubt in a courtroom, leading to a prison sentence. Because these laws didn't exist in the 19th century, no official from that era could ever be individually tried.
So we basically can't put ghosts in handcuffs.
Right, you can't indict the dead. What we are doing today is measuring historical facts against a later moral and legal standard. The defense would argue that while you can assign moral or historical responsibility to a continuous government entity, you cannot legally convict the individuals retroactively.
Oh, I see.
It is the vital difference between a historical verdict and a legal indictment.
Okay, so the defense blocks individual indictments based on retroactivity. Let's move to their next major argument, which addresses the sheer scale of the demographic collapse. And this is where we have to talk about disease.
This is perhaps the most critical analytical distinction in this entire history. The overwhelming majority of Native American deaths across the centuries were caused by introduced epidemic diseases, things like smallpox, measles, and cholera, to which native populations had no acquired immunity.
And the defense points out that a virus doesn't have intent. Smallpox doesn't have a political agenda. While the collapse of the population was world-altering and tragic, much of that dying was neither intended nor deliberately caused by government policy. And the law of genocide strictly requires intent.
Exactly. An epidemic is a tragedy of unfathomable proportions, but an epidemic is not a crime. Any honest historical accounting must separate the massive toll of disease from the smaller, though still horrific, toll of deliberate killing and deliberate policy.
And the defense would say that if you try to claim all deaths were genocide, you actually weaken the legal case. Because if you blur the lines between a virus and a militia, you lose the crucial element of specific intent required for the legal definition to hold up in court.
Right. By narrowing the focus to where intent actually exists, like the California militias, the legal argument actually gets stronger. You cannot prosecute a virus.
That makes a lot of sense. Let's look at the defense's argument regarding the boarding schools. Because they argue something that is deeply uncomfortable for modern sensibilities. And that is the sincerity of the policymakers.
This explores a very difficult truth about historical context. The architects of the assimilation policies, including Richard Henry Pratt and reform groups who called themselves the Friends of the Indian, often sincerely believed they were saving Native people.
Saving them by completely erasing their culture.
Yes. They viewed assimilation as a rescue mission. In the context of a rapidly expanding, industrializing nation that was frequently violently hostile to Native presence, these reformers believed that Native populations were facing total physical extinction.
So they were helping.
They argued that the only way to save the physical lives of Native people was to eradicate their traditional cultures and assimilate them into white Christian society.
So the defense argues that federal policy wasn't one continuous, monolithic plot of physical destruction. It swung wildly. Sometimes it was removal, sometimes it was violent conquest, and sometimes it was this paternalistic, destructive assimilation.
And under the law, if the actors genuinely believed they were helping individuals survive, even if their method involved cultural eradication, it deeply complicates the mental element of intent. It forbids a simple caricature of cartoonish evil.
Yeah, the law demands specificity.
Exactly. The harm done by the boarding schools was profound, generational, and traumatic. But the defense argues that a sincere, albeit deeply misguided and destructive, belief in uplift is legally distinct from the malicious intent to annihilate a people.
Which brings us to the final piece of the defense, and that's the ongoing scholarly debate. Because this isn't just a settled matter among historians who study this era.
Far from it. There is a very active, robust academic debate about the terminology itself. The defense asks a vital question here. Does using the singular word genocide to cover the entirety of the Native American experience flatten a complex 2.5-century history?
Many scholars argue that while genocide perfectly fits specific events like California, it might actually be the wrong legal frame for the broader relationship.
Right. They suggest that other legal frameworks might be more accurate. For instance, ethnic cleansing, which focuses on the forced removal of a population to clear land for another group. Or settler colonialism, which focuses on the structural logic of land acquisition and population replacement, rather than outright physical annihilation.
So if the primary goal of the U.S. government was usually to acquire land and destruction was just a horrific byproduct of that goal, then settler colonialism might better explain the policy outcomes than genocide, which requires the destruction to be the primary goal itself.
Exactly. And that is a respectable, live debate in academia. It shows that attempting to apply a single mid-20th century legal category to centuries of varied, evolving history can be analytically problematic.
Right.
The defense rests on the idea that nuance, historical context, and precision in our terminology matter immensely if we really want to understand what actually happened.
Okay. We have heard the law. We have heard the prosecution present the facts and the internal government audits. We have heard the defense vigorously challenge the application of those laws, citing retroactivity, disease, and historical intent. The trial phase is officially over.
The evidence is in.
But having heard all of this, How does the modern United States actually process this history? Because this is where our deep dive shifts from the 19th century directly into the headlines of today.
Because the theoretical exercise we just engaged in applying modern standards to past actions is no longer just a thought experiment for history buffs or law seminars. It is exactly what is happening at the highest levels of government right now.
Let's look at the moral weight of modern apologies. In June of 2019, California Governor Gavin Newsom issued a formal executive order and an apology to California Native Americans.
Yeah.
And he didn't mince words. He didn't hide behind euphemisms.
No, he was very direct.
He explicitly used the word genocide to describe the state's historical actions, specifically acknowledging the state-funded militias. And he also established a Truth and Healing Council.
And then, even more recently, in October 2024, President Joe Biden delivered a historic address at the Gila River Indian community in Arizona. It was the first formal presidential apology for the federal Indian boarding school system in American history.
And he explicitly referred to the era as a sin on our soul.
Yes, he did.
Think about how these modern apologies directly collide with the defense's argument of non-retroactivity that we just discussed.
Right.
The defense said you can't apply modern laws to past actors. But through these apologies, the government is saying we absolutely are applying modern moral frameworks to the past.
It's a fascinating shift.
We are retroactively taking responsibility, not necessarily as individuals facing jail time, but as a continuous state entity that still exists and still holds treaty obligations today.
And this raises a crucial point about the utility of these international legal frameworks. These formal apologies utilize the conceptual architecture born at Nuremberg and in the UN Convention to address historical harms. By formally acknowledging acts that align with crimes against humanity or genocide, the government fundamentally alters the current political and legal landscape.
It changes the whole vocabulary of the relationship.
Exactly. It shifts the conversation from a vague, passive sense of historical tragedy, where bad things just sort of happen, to a specific, active acknowledgement of state-sponsored harm. And that formal acknowledgement is the necessary prerequisite for any current, ongoing debates around historical reparations, truth and reconciliation processes, and the strengthening of federal obligations to sovereign tribal nations today.
So let's do a final summary of where the record stands. We set out to find which acts present the strongest prima facie cases under modern law.
If we look at the evidence objectively, the strongest cases are distinct. The massacres, particularly Sand Creek and Wounded Knee, provide the strongest fit for crimes against humanity, as they were undeniable, systematic attacks on civilian populations.
The California era, from 1846 to roughly 1873, presents the strongest legal fit for genocide because it combines mass, state-funded killing with the explicitly documented intent of extermination by the state's leadership.
And finally, the off-reservation boarding school system provides the most precise, literal fit for Article 2, clause of the Genocide Convention, the forcible transfer of children. It is the exact mechanism named in the treaty, now fully documented, quantified, and apologized for by the federal government.
But as we said at the beginning, the goal of this deep dive was never to sentence the dead. You can't put a ghost in handcuffs.
Right?
The goal was to see the historical record clearly, illuminated by the light of the standards the world eventually agreed upon. We wanted to look past the murky waters and see the structural machinery of what actually happened.
We provided the legal definitions, we presented the historical actions, and we gave equal weight to the defenses of retroactivity, the massive variables of epidemic disease, and the complexities of historical context. The facts are on the table.
And so, the verdict is yours. We've given you the law, we've given you the mechanics, and we've given you the arguments. We've shown you the ghosts in the courtroom. What do you decide? How does viewing this history through the strict clinical lens of modern international law change your understanding of the American story?
It's a lot to process.
It really is. And I want to leave you with a final provocative thought, something to mull over that stretches beyond the boarding schools and the massacres we've talked about today. If retroactively applying the law teaches us more about who we are today than it does about the past, well, what actions is our society taking right now? What are we doing today that is completely 100% legal, but for which a future international court 50 or 100 years from now will have to invent an entirely new word to condemn? Think about that as you leave our courtroom today.